New York's Chief Administrative Judge Lawrence Marks, welcome to New York Now.
Thank you.
Well, dispensing justice to 19.5 million people spread over 55,000 square miles was always going to be tough. But in digging into the background of law reform and justice reform, it seems like the proposals for streamlining the structure of the courts have been around for decades, not just recently. It's an old issue, isn't it?
It's not a new issue. The last 5 or 6 chief judges of the state have tried to change the system, to get approval in the legislature, to change the system. Prior governors have tried to do it, so this is not a new proposal.
Replacing 11 courts with 3, roughly, I'm simplifying. Some of these courts that you're talking about replacing would be ones that DeWitt Clinton and Gouverneur Morris would recognize. I mean, New York's an old place, and so are these courts.
Well, our court of general trial jurisdiction is called the Supreme Court, which, by the way, should tip you off that something's wrong. In every other state in the country, the Supreme Court is the high court of the state. And here in New York, our high court is the Court of Appeals, and the Supreme Court is the Court of General Trial Jurisdiction. And it actually dates back to 1691, so you're right. These are venerable institutions. And of course, we would preserve the Supreme Court under our proposal and merge some of the other courts into a consolidated Supreme Court.
You've called the existing system unnecessarily complex. Aren't these courts doing the jobs that they were created to do?
They are, but the difficulty for us, I mean, think of the court system as a large business, which it really is. I mean, we don't obviously exist to make a profit, but it's a large business. We're present in all 62 counties of the state, in over 300 courthouses. We have 15,000 or so employees. We have 12 to 1,300 judges. That doesn't include another 1,800 town and village judges who are actually not part of our proposal. But it's an incredibly complex system, and it requires good management. The business that we do is we resolve cases, people's cases and controversies. And we try to do that as fairly and expeditiously as possible. And with this complexity and proliferation of courts, trial courts, it makes it much more difficult for us as the managers of the state court system, this big business that it is. It makes it much more difficult for us to move resources around quickly and efficiently to where they're most needed.
A lot of the proposals have as part of their argument that this would save money. But if you're merely folding courts into each other and not shutting them down, how does that save money?
Well, it's a good question. And there are really 2 parts to that question. Would it save the court system money, as a whole? And the answer to that is no. In fact, we've done an analysis, and it would cost $13 million to implement this proposal, mainly because we would be taking judges in other courts and putting them into the Supreme Court where the salary is modestly higher, and some of the staff salaries, the judges' personal staff and the court staff salaries would rise also. But we have a $3 billion budget. A $13 million additional cost is less than 1/2 of 1% of our budget. So relatively speaking, that's a modest cost. Where there are cost savings, however, are to the litigants, where delay and going back to court time and time again without getting the case resolved obviously costs litigants money. That costs them extra attorney's fees. It costs them money because they lose days at work. They may have childcare costs, their transportation costs. So by making the court system more efficient, which will allow for faster resolution of cases and fewer court appearances and the necessity to come to court as many times, that will obviously save the litigants a substantial amount of money.
One of the great civic successes of the last 30 years in this state is the tremendous reduction in all kinds of crime. Has that given the current system some extra breathing room? Courts simply are not as crowded as they were in the late 80s.
We do have a little more breathing room. I think we've gone from with respect to criminal cases, a crisis situation not that long ago when there were far more violent crimes, unprecedented numbers of violent crimes that were prosecuted in courts, and a lot of low-level crime was prosecuted in courts. But there's no question that criminal caseloads have declined. But that's just one aspect of our caseloads. There are civil caseloads. There are caseloads involving family law problems. There are caseloads involving trusts and estates issues, wills, in our probate courts. And we still, in the court system, statewide, have over 3 million cases filed a year, 3 million.
Some of the distinct courts that would go away include the family court, the surrogates court, the court of claims. In some of these courts, there are people with experience that's highly specialized because of the kind of cases they deal with. If you fold the courts into each other, will you be frittering away some of the value of some of that experience?
We actually wouldn't, although by merging these other courts into this consolidated Supreme Court, all of the judges would be qualified and available to handle any and all of the cases. And that's where we feel that there can be great efficiency returns. But of course, individual judges have their own individual experience and expertise. And we would take advantage of that because we would, although, as I said, they would all have full jurisdiction and authority to handle any of the cases that would come to this consolidated court. We would set up divisions, particularly in the higher volume jurisdictions. We would set up specialized divisions, a criminal division, a family division, a commercial division, a probate division. And we would, where we have judges with particular expertise in those areas, we would more likely than not be assigning those judges to those particular divisions.
If you make this as a value proposition to the people of the state, can you say to them, look, if someone has a beef with you, or if you're in some kind of trouble, this system is simply going to work better for you?
We can make that assurance to people who come into our courts because I would say people who have experienced litigating cases in the New York courts have seen delays and inefficiencies in the handling of their cases. And believe me, delay really matters. I mean, if you're a criminal defendant and you're detained while your case is pending, waiting for your trial, you can wait indefinitely for a trial. If you're a tenant in a housing court matter, you may have to keep coming back to court again and again and again until your case is resolved, which of course can lead to expenses and inconvenience, as we discussed. If you're a small business and you're involved in litigation in the New York courts, your attorney's fees and the cost of the litigation can increase and increase while the case languishes. So yes, by streamlining our incredibly complicated court system and making it more efficient and being able to assign the resources to where they're most needed and to be able to do that efficiently and quickly, there'll be real results for people who litigate in our courts.
Let's talk a little bit about mechanics. Earlier in New York history, when big reforms have been passed like this, it required amendment to the state constitution. Can you do this, something this big and this thorough, without amending the state constitution? And how would you propose doing it?
This absolutely requires an amendment of the state constitution. These are fundamental, foundational changes in how our court system is structured in the state that involves, of necessity, amending the Constitution. We've started that process. To amend the Constitution in New York is not a simple thing to do. It's a cumbersome process. It requires passage of the proposed constitutional amendments by two successive legislatures. And then if there is second passage in the legislature, then the amendments go on the ballot for approval by the voters. So it's not something that can happen quickly or easily, but we've already started that process and are looking forward to and doing everything we can to ensure that we see first passage in the the upcoming legislative session that will start in January.
Chief Administrative Judge of the State of New York, Lawrence Marks, thanks for talking to us.
My pleasure.